So good afternoon and welcome to today's webinar, Life Beyond Lockdown. What should employers be thinking about now? My name's Fiona Herrell. I'm a partner in the Employment and Immigration team at Brodie's, and I'm joined today by Brian Campbell, one of our legal directors. In terms of setting the scene, obviously we've had clear instructions now for the last 7 weeks or so to stay at home, to protect the NHS and to save lives. But what has become particularly clear, certainly over the course of the last few days, is that we're expecting to move into the next phase of the management of the pandemic, and we're anticipating there to be some sort of relaxation of the current lockdown regime. Now, we don't know the detail yet. We also don't know what approach is going to be taken sort of north and south of the border. There certainly seems to be the potential for different approaches to be taken, and we're sort of waiting for further detail to be communicated by the governments on that. And so what we really thought was actually this session would be very helpful for HR professionals who are starting to think about what a return to the workplace might look like once there has been a relaxation of the current regime, and to identify some of the key HR issues for you so that you can really get ahead of the curve on that. So in terms of what we're going to cover, I'm going to have a look at some of the issues around identifying who will return to the workplace first. Brian is going to look at some of the changes you may be thinking about making in relation to your people, whether those are contractual changes or otherwise. And then we'll then have time at the end for some questions that you'll hopefully be submitting for us. I think before we get into the substance of my session, it's really important that I stress that today we're looking at things through a really narrow HR and employment law lens only. That's not to say that these are the only issues that you're likely to be considering as part of any sort of return to the workplace plan. Clearly, there are going to be health and safety obligations, things like how do you ensure social distancing, do you need to provide PPE, can you get PPE? It wouldn't be for us to sort of cover those considerations today. We have a health and safety team who are dedicated and specialists in that area. And similarly, there might be data protection and data privacy matters that you're thinking about as well. One of the large accountancy practices has come out today saying that they're thinking about fortnightly testing of their employees once they're back in the workplace. And clearly that brings all sorts of data protection and GDPR compliance issues to the fore. So what we're envisaging is that once we've got the detail of the government plans, we will come back to you with details of further webinars, one with our health and safety experts and one with our data protection experts. And if you're thinking about joining those sessions, and we would really like you to, you might want to think about bringing along your health and safety and data protection colleagues too, just so that you're all on the same page on this. So let's get cracking. I'm starting with who will return to the workplace first. What we know, although we've not seen the details of government plans yet, is that it's inevitable that there's going to be a restriction on the number of individuals who can attend the workplace at any one time. We've certainly seen that in some other jurisdictions that are slightly ahead of us in terms of their relaxation of lockdown. And that means that employers are going to have to think about fair way to decide on who's going to be returning to the workplace. Approaches will differ across industries and sectors, so it's definitely not a one-size-fits-all. Probably starting with identifying which areas of the business need people back at work first. So who is it that makes your money for you, and can you get them back to the workplace as your sort of first priority? Even once you've identified those parts of the business, though, you're going to be thinking about how many people can physically be in the workplace at any one time. And again, that will depend on the type of organisation that you are, the type of building that you have, but you're likely going to have to drill down into some sort of selection process, possibly asking for volunteers and maybe some sort of combination of the two. If we look at those in a bit more detail, so if you're thinking about a selection process, we would be recommending that objective criteria should be used, so that it is a formal process that's undertaken. It's not just asking managers to sort of submit names with no basis for it. Reason for that, we want to make sure this is a fair process. We also need to be mindful of the fact that the usual discrimination protections will apply, so the risk of discriminatory treatment must be considered too. I think it would be fair to say that you should probably anticipate that there might be decisions made in relation to selection that are challenged, and we'll come on to have a look at some of the tricky issues around this. And so trying to resolve issues by engaging with the workforce will be important. What you might even want to think about is engaging before you start any sort of selection process. So have you got a feel for how people are coping with lockdown, what their views are about returning to the workplace or not, particular challenges people might be facing in terms of childcare commitments or travelling to and from work, for example. Perhaps some sort of staff survey would be a good way of collaborating or collating views on that, and then allowing you to make a sort of an informed decision as to how you'll move forward with selection. Another option that might be quite popular is operating a voluntary process, so asking people to volunteer to return to the workplace first. As you would with a voluntary redundancy process, I think it's just very clear that you reserve the right to refuse applications. So it's not sort of if somebody volunteers that will automatically be accepted. And if you are going to refuse a voluntary application, that you're very clear that the reason for refusal is fair, but also that it's documented just in case, as I said, you end up with a challenge later down the line. One practical point around who will return is that you may well be looking at employees who have been furloughed and asking them to return to the workplace. Now, we know under the job retention scheme that individuals who have been furloughed are not able to do any work. So from a practical perspective and for a planning perspective, you'll need to make sure that the period of furlough is brought to an end before those individuals are then required to come back to the workplace. So checking what sort of notice period you've agreed with the individuals who are furloughed. If there's no notice period, we'd be recommending that a reasonable period of notice is given. So that's sort of thinking about who might be coming back in the first instance. There's then, I guess, a question around what about the people who aren't coming back? As I said, you might have people who are furloughed and you're claiming or making applications in respect of them under the coronavirus job retention scheme. That's already been extended once. It's currently set to run until the 30th of June. There is the option for that to be further extended, but what we also know is that the Chancellor is looking at that scheme and how it can be tapered off to dovetail with the relaxation of lockdown. So the sort of government is viewing that the two will go hand in hand. So we don't yet know the detail on that, and that's something to keep an eye on. But of course, there will be the option to keep people on furlough at least until the 30th of June. You might have people who are currently working from home, and potentially if they're able to work from home and do their work from home, you will leave that to be the status quo for a little bit longer. I'm not going to go into the health and safety considerations, as I said at the outset, but what I would say is we know that the decision to have people work from home came about quite quickly in lots of organisations. So if it's now going to become a longer term option, then it would be a good idea just to make sure from an internal perspective that you're meeting your health and safety obligations in relation to your home workers. I've popped on the slide annual leave. This is unlikely to be a longer term option, but if you haven't done anything yet in relation to communicating with your workforce about annual leave, you might want to think about whether that's something you want to do now. Under the relevant legislation, employees can be required to take holiday providing that they're given sufficient notice. You'd also want to check what the contract of employment says. Now, the slight caveat to that is it's not yet clear if you can require people to take holidays whilst they're furloughed. So that's a slight wrinkle, but otherwise, if you've not done anything in relation to annual leave, you might want to think about doing that as part of some sort of return to work plan. That then takes us into the tricky issues, and I think it's safe to say that we know people are reacting differently to being in lockdown. Some people thrive being at home and working from home. Some people obviously are furloughed and perhaps sort of enjoying not having to work. Other people are really struggling with being in lockdown and are suffering from isolation issues and other issues as well. So I think probably the headline point is not to make assumptions about how people are coping with lockdown. When you go out to communicate to people about returning to the workplace, I think we should probably assume that there may be some who are unwilling to return to the workplace. Potentially they've been at home, they've been furloughed, and they're on full pay, so there's perhaps little incentive for them to come back to the workplace. But there might also be people who have some of these sort of genuine concerns that I've listed on the slide. So there might be concerns in relation to health and safety measures, for example. So an individual might be saying, the cleaners who do the cleaning in our office are not very good, and I therefore have concerns about coming back to the building because I know that the cleaners just do a quick wipe around, and therefore I'm concerned about it. There is protection under the Employment Rights Act, both from detrimental treatment and also from dismissal, if in circumstances of danger which an individual reasonably believes to be serious and imminent, and which he could not reasonably have been expected to avert, he refuses to return to his workplace, or he takes appropriate steps to protect himself or others from danger. So an individual in that situation, if those, or if it's a reasonable belief, and it's a belief that is reasonable for them to have, may well have protection under that piece of legislation, as I say, from detrimental treatment or dismissal. Similarly, in relation to whistleblowing, we know that people have protection as whistleblowers if they make a disclosure of information which, in their reasonable belief, is made in the public interest and tends to show a breach of a legal obligation, for example, or that health and safety is being or is likely to be damaged. So again, you could see a situation where somebody blows the whistle in relation to health and safety concerns about returning to work. And therefore has protection as a whistleblower. And we've also got disability discrimination risk clearly in play here too, and that risk must be factored in at all stages. But again, you might have individuals who are shielding and therefore disabled under the equality legislation, and so having to think about how your decisions are impacting them, and whether you've got a duty or whether there are reasonable adjustments that you can make in relation to them to remove any disadvantage that they're suffering. None of these things are going to be easy to decide, but I guess what I'm saying is, to the extent you've got people who are saying, I'm not willing to come back, it's not a case where you'll just jump straight into well, that's a failure to comply with a reasonable management instruction, or, well, you're absent without leave, therefore we're trotting off down the disciplinary path, because there may well be sort of additional risks with doing so. And from a practical perspective, even if you go down a disciplinary route, it's unlikely to resolve the issue. These are issues that need to be resolved. Similarly, and on the flip side, you might have employees who are not asked to return, but they are desperate to return for some of the reasons I alluded to earlier. I think, again, concerns should be listened to and properly considered before a decision is made. We may see an increase in grievances, and grievances will be quite tricky to manage in this sort of remote world. So if possible, I think trying to grab hold of any potential issues that look like they might turn into grievances and grappling with them as quickly as you possibly can to try and stop them then escalating into formal grievances would be a good idea. I'm now going to pass on to Brian, who will talk about some changes to terms and conditions and other changes.
Thanks, Fiona. So it's probably realistic that you may be looking at making some changes to coincide with people beginning to come back to work. That may be because the way that you're operating as a business has changed, or it may be that you're looking to cut some costs. There are clearly many possible ways that you might do that, and some of those we've listed on the slide here. So you might be looking at changes to job numbers or functions, or working hours or patterns, or you may be looking to amend pay levels or calculation methods. You may also want to look at other benefits such as commission and bonuses, and perhaps things like car allowances, whether those are still sustainable. And you may also want to review things like medical cover or permanent health insurance or pension benefits. So can aspects of those, such as eligibility or the level of funding that you provide, or even the amount of cover, can those be changed? Now, whatever you think about doing, before you begin, you'll need to identify the relevant contractual term and check if variation is possible under the contract. And even if it is, don't forget about the duty to preserve mutual trust and confidence. So try to make any changes as sympathetically as you can. It usually helps to have a good business reason to do that, and to give people as much notice as possible, or at least an explanation of why you're taking those steps. And you should also, in a practical sense, check if there's already an information and consultation agreement in place, or a collective bargaining agreement with a recognised trade union, because clearly, if so, those would be the mechanisms that you would look to use. If there isn't an express right to make the change in the contract, then your options are basically restricted to three, which we've got on the next slide. So you can either try to make the change with the employee's consent, which is clearly the most straightforward and probably the safest if you can achieve it. It's usually better to document any changes in writing just to avoid any uncertainty or disputes further down the line. But you will have practical considerations in the post-lockdown world, particularly if there's no mechanism in place for collective negotiation of these terms. It will basically have to be done on a one-to-one basis with each individual. So you may have to think ahead about the timescale and the method that you need to follow in that kind of situation, and how you'll deal with people remotely if you begin to make these changes before they return. The second alternative option is to unilaterally make the change, which clearly is more risky. While employees may not be as keen to resign and claim that they're constructively dismissed if you try that option, nevertheless, they may stand and sue, as it's said, and there may be certain types of claim that they can make while remaining in employment, whether that might be a discrimination claim or a wages deduction claim, or even a contract claim, which they could raise in a court. So if you're hoping that they'll accept the change, whether that's expressly or by implication, be aware of the risk. And the third alternative option is simply to terminate the contract and offer to re-engage people with the new terms that you want to introduce. That still amounts to dismissal in a legal sense, so you'll still have to follow a fair process. And be aware as well that collective consultation obligations may arise if the numbers that you're talking about are 20 or more. That will have a knock-on effect in terms of the timing and the timescale of that process. So be aware of that as well. Also a valid question is whether you might be looking at redundancies around this time. There'll be a redundancy situation generally where there is a closure event, whether that's a department or a location or even your whole business. Or if the business perhaps is continuing, but it's with a reduced capacity, or you need fewer people to do the work, perhaps to reduce staff costs, or otherwise that you need to reorganize people into different groups. Again, collective consultation obligations should be uppermost in your mind. They'll be triggered if you're proposing to dismiss 20 or more people at one establishment within a 90-day period. And that will impact again on your timing and also require quite careful planning. For example, if you're requiring to hold an election for employee representatives and do that remotely. So it may even be worthwhile getting a staff council or something similar in place just now, if you don't have one and you don't recognise a trade union just for this purpose, and perhaps also more generally just to help communication across your workforce. Worth bearing in mind that furloughed employees can act as employee representatives in a collective consultation, so they're not working in that sense and they're not generating revenue for their employer. And although the scheme guidance doesn't directly address whether furlough will be broken by an individual attending a redundancy consultation meeting, that would seem unlikely. Just again, moving on to some potentially tricky issues that might arise in relation to terms and conditions and redundancies. An obvious question perhaps is, what does the job retention scheme do to an employer's duty not to dismiss staff unfairly? Some unions are saying that not to use the furlough option when it's available and just to make redundancies instead could be unfair in itself. But this is probably going to be case specific in reality. The job retention scheme is explicitly not to be used if an employer believes that the jobs will not continue to exist. So you may have to make a judgment call at some point on whether furlough is just putting off the inevitable. Another question that may arise is in relation to notice and notice pay. So should you, for example, pay for notice at the 80% rate if that's what your workers have been getting during the furlough period, or should they get a higher or full contractual rate? Now, there isn't a completely clear answer to this in the scheme rules, at least, and opinions vary. So it may well hinge on the reason why they're on furlough. So for example, is that because of their illness or because they're shielding or because either of the parties has agreed or asked for the furlough to be put in place? And it may also depend on how they're paid and whether they're paid a fixed amount for the work that they do or whether their pay varies depending on the amount of work or the amount of hours that they perform. So those may be relative considerations as well. And there is a body of opinion that says basically that an employment tribunal would almost seek a way to ensure that employees got full notice pay if they're being dismissed, on the basis that the job retention scheme should be set aside in that case. So that's one that remains to be seen and to be clarified as we go forward. Another issue that may arise in your mind, particularly if you're making collective redundancies, is whether the special circumstances defence may be available to you. So as you may know, employers can dispense with the 30 or the 45-day consultation requirements if special circumstances exist that justify them doing so. Now, policing of that exception by tribunals has traditionally been quite strict, just to avoid abuse of the option. And so to be able to rely on this option as a business, you're likely to need to have a clear evidence that full consultation would be critical to the future of the business. And even still, you may have to think whether you can consult for a shorter period rather than not at all. And just to wrap up, here are some other changes that you may want to consider. You may want to look at some of your policies like these listed on the slide, which may need to be changed in light of the new rules and practices which are become the new reality. And bear in mind that an employer will have a particular duty to consider reasonable adjustments in the case of disabled employees who are returning to the workplace after a period of lockdown. Think also about how requests for flexible working are going to be treated. It may well be that an informal approach is better and more appropriate if the change is going to be shorter in its term rather than going straight to a formal process. So some of your policies may have to change because of their subject matter, like the ones we've listed on this slide. But you may also need to look at how you, as a business, and HR especially, deal with change and respond to any issues which arise, whether that might be a request for flexible working or a performance concern or absence, conduct, or even whistleblowing. So will you have the capacity if there's an increase in activity in those areas, and do your policies have the flexibility that you may need? And finally, it may be appropriate to put in place additional support measures for your returning staff, or even just to signpost those which you already have in place, whether that might be an employee assistance programme or occupational health, or if you have them, mental health first aiders or any virtual GP service, just to give people a help to deal with all of this change and uncertainty in a separate space from line management. So that really rounds off the presentation, and it's now over to your questions.
So I'm just having a look at Brian, and there's a question here around, do we know when it will be announced if the job retention scheme is being extended? And I know we were having a chat about that just before we kicked off the session, if you want to cover that off.
Yeah. We're still waiting on it being officially clarified when we might be able to hear more, but you can almost track back from the point to which the scheme has already been extended. So we know that it's going to run in its current form at least until the 30th of June. Now, the government will be well aware that employers will be wondering at what point they might have to start consultation if they are potentially looking at making redundant a larger group of employees. The maximum period of consultation they might be thinking of is 45 days. So if we go back from the end of June, it may well be that the government will be looking to clarify the position before the middle of this month, so that they don't have the avoidable situation of employers beginning collective redundancy consultation when they may not need to, because the furlough scheme is actually going to be extended.
Yeah. Just having another look. So somebody has asked, could people appeal their selection of being in the first group to return to work? I wouldn't envisage there being a specific appeal process necessarily, but I think it's probably better approached if it's a more collaborative exercise. So trying to engage with people to understand their concerns about their selection. You might even say that their selection has been done on a provisional basis and you'd like to discuss that with them. And then if they have concerns, then that gives them an opportunity to air those concerns so that you can try and address those and get them resolved in order for that person to come back. Or if that person tells you information that you didn't otherwise or didn't previously know, that might change your decision as to whether or not that individual would be appropriate to come back to the workplace in the first group. So I don't think it would be a sort of necessarily a formal appeal process, but I do think some sort of engagement with individuals who've been provisionally selected is a good idea.
Okay, I see another question here, which is that if you make people redundant, can you leave them on furlough for their notice period and just top up to 100%? Or can furlough money not be used as part of notice pay? Like, again, that remains to be clarified. There is some thinking that yes, furlough payments can be used to meet notice. There isn't anything certainly in the guidance that says you can't do that. So your options are to use the furlough and keep things at 80%, or you can top up to 100% during notice, which you might arguably be the safer option to avoid any future claims.
Yeah. Here's a really interesting question. What is the legal status of the government guidance? For example, in relation to when employees should work at home. If the rules become different in Scotland and England this Sunday when the announcement is made, should we have different rules for our workplaces in each location? So the legal status is that it's a guidance document rather than a sort of strict piece of legislation. Nonetheless, we do know, for example, that a site, I think it was a construction site in Glasgow that had opened back up, the police attended and the site was shut down. I don't know exactly what the legal basis for that was, but we know that there is sort of some policing going on this. So if the Prime Minister's announcement on Sunday is that there's a relaxation in a particular direction. We know from the First Minister today that her view is that we're not ready yet in Scotland because we're in a slightly different trajectory from where England is. And you are a sort of across the UK employer, then yes, I think you may well be in a situation where you have perhaps people returning south of the border, but not north of the border just yet. And that will require you to take slightly different approaches in each of those locations.
Okay, and perhaps I wonder if we've got time just for one more question. We have one here which says, if we end furlough and employees refuse to come back to work and they're not sick, vulnerable or shielding, what are our options as an employer? Can we terminate their employment? Well, that's an interesting one. It's certainly a possibility, but it's probably one to be approached with caution. You could, I suppose, look at that as a failure to obey a lawful instruction, which under normal circumstances might at least warrant some sort of disciplinary process to be activated. But of course, these are slightly different times. I think that the necessity to get to the bottom of the employee's motives for not returning would be even greater. So I think with tempered with caution, I think you would want to investigate and explore that further before you took any action, particularly as extreme as termination of employment.
I agree. I'm conscious of the time, that's 4 o'clock on the dot, so I think we will wrap up there. There are some questions that we haven't quite managed to get to, but for those of you who have given us your names, then we will follow up with you separately after the session. Thank you very much for joining.